Good morning, Mr. Milby.
Good morning.
Can you both hear and see me?
Yes, Your Honor.
Thank you. Let the record reflect this is 18 CF 103, People of the State of Illinois versus Matthew A. Milby. The defendant appears by video conferencing. His attorney, Mr. Murray, is present. Matt Klon and Mr. Boonstra of the Lee County State's Attorney's Office are present. We are here today for a pretrial conference. Mr. Murray, you have filed a motion for discovery.
I have none.
Okay. Have you received any discovery from the state at this point?
No.
State ready to present discovery?
Your Honor, we have no reports at this time, as was discussed with Mr. Murray and two agents of the Illinois State Police yesterday. We anticipate to having most narrative reports by the end of next week. We've already met with the lab in Rockford, discussed with them what we wanted tested and how much and the time frame. I asked the lab to have the posture of this matter going to trial in August. So I believe they're going to be working throughout this month, and with any hope we would have lab reports by the end of June. So we should have discovery ready to disclose, at least all initial, by the end of next week. And I can follow up the lab to see what kind of progress. So far with the lab, we've requested ballistics, gunshot residue, fingerprints, biology of blood, and DNA on multiple items.
Okay. And you believe that you'll be having that to Mr. Murray by the end of June?
That is my hope. I asked the lab to anticipate this matter going to trial in August.
Okay. I received from Judge Ackert, who received from KSB Hospital approximately 240 pages of medical records of Mr. Milby. I will present those to the state. The state will copy those for Mr. Murray. Each attorney is ordered not to further disseminate these records unless that is approved by the court, and only to use these records for the purpose of and during the course of this litigation. Upon completion of this litigation, each party is to destroy the records. They are not to be used in any other case or proceedings. So, Mr. Klon, if you'll please come up and acknowledge receipt of those.
Yes, thank you, Your Honor.
Mr. Murray, do you want to set a date out towards the end of June for discovery, or how do you wish to proceed?
Your Honor, our concern is, and we understand that there's a lot of investigation here, but it's what we're concerned about is that any delay at this point be attributed to Mr. Milby. I believe the law is that a period is not chargeable to defendant because to obtain discovery because he has a right to discovery, and the time necessary to complete it should not be attributable to delay. That is the case of People versus Manna, 96 LA 3rd 506, 2nd District case from 1981, which cites the Illinois Supreme Court, People versus Crawford Distributing, 7302nd 70. So at this point, we would not acknowledge any sort of delay occasioned by Mr. Milby as we await for these reports. And so we're fine with a pre-trial in late June as long as that delay is occasioned by the state. Further, Judge, we want to reserve the right to possibly object to some of the contents of those medical records once we receive them, if they are protected by any mental health code or HIPAA or anything.
Okay. Well, they were released pursuant to a HIPAA order, so you certainly have the right to do that. The state have a position on who should be charged with the continuance.
Well, if the defendant's demanding speedy, then I suggest we set a trial date within that speedy time frame. August 20th would be 96 days. The allegations occurred on May 16th. The defendant was taken into custody in arraigned on May 17th. Preliminary hearing status May 23rd. Preliminary hearing was yesterday. Again, if the clock's ticking against the state, I'll accept that, but let's go ahead and set a trial date and let's move forward. I don't think the defense can assert speedy, demand a speedy trial, but then object to the setting of a trial date. So I think if the clock's ticking, and we will move, once we have discovery, we will get it to the defense immediately.
Okay. Mr. Murray, late August for trial?
Judge, the week of August 20th or 27th seems okay. I do have a matter with Judge Fish on August 21st that I would need to move, which might be difficult to move. But August 27th, that week is doable.
Okay.
I would anticipate at least maybe 3 days with the jury.
Mm-hmm.
But potentially a week. And I'm sure the court will let us know how it wants to do jury selection in this case. The state's case in chief, without reading the reports, but I anticipate maybe a week to a week and a half. So it might be prudent to reserve anywhere between 3 and 4 weeks for this trial.
Okay. If we start, Mr. Murray, you indicate that the week of August 20, with the exception of the 21st.
Yes, the afternoon of the 21st is really something. There's an attorney traveling from out of town.
So if we were to start jury selection on the 20th, break for the afternoon, that wouldn't affect anything at that point, is that correct?
That's correct.
Okay. August 20, 9 o'clock. And we'll set 3 weeks.
I didn't check the 3rd.
I don't know what the state's going to do for a week.
I can do the 3rd week
Okay.
as well.
All right. Anything else we need to do this morning?
So do you want to set aside a state then in June, Your Honor?
If the parties agree that that's a good date, yeah.
And I'm fine with doing this on Fridays at the end of Mr. Murray's usual call. That's agreed with the report.
Oh, sure. Usually between 10:30 and 11, we get have the public defender cases concluded by then, so that'll work. So you want like the last week in June, or the last week, or the first week in July?
I'd like to have numerous statuses just to make sure. Again, I'm asking the lab to do this. I'm not in control of the lab. So if we have to address things as far as timely discovery.
Okay.
So I'd like to have numerous statuses, if that's okay with the court.
Absolutely.
So end of June would be fine with me to start the first one.
Last week in June, Friday?
29th?
Yes, 29th at 11.
June 29th at 11 o'clock. Mr. Milby, have you been able to hear and understand everything we've said so far?
Yes, Your Honor.
Okay. It will not be the normal that you will be brought over. Mr. Murray may ask that happen on certain occasions, but unless we are doing something significant in your case, we will probably do it exactly the way we did today, that is by video conferencing. But if at any time you do not hear or do not understand, please let me know, and we'll see that things get squared away.
All right, thank you, Your Honor.
Thank you. June 29th at 9 o'clock, gentlemen. Thank you very much. 11 o'clock, I'm sorry, 11 o'clock. Thank you. All right.